Okay, class, we're going to start now with Chapter 8, which is Pretrial Procedures and the Criminal Trial. This is one of the sections of the course that I'm always glad to teach. As an attorney, I feel very comfortable talking about a lot of this stuff, and I think I can give you a little bit more of an appreciation of how things practically work, as opposed to some of the more theoretical aspects of this entire system, although theory does play a role here. Okay, so let me just move this forward. This is going to take a little bit of finagling. So the learning objective is not terribly critical for us to look at. I'll let you look at some of those slides. Some of this terminology, I think it's going to be going to come back, and we can look at it for review when we talk about reviews for the final and midterm. Okay, the first real part of what goes on is the initial appearance. Now, because of certain constitutional interpretations, the Supreme Court has said that after someone is arrested, brought into custody, they should promptly be brought before a neutral judicial magistrate, a judge in most cases, but sometimes a lower figure in the judicial system. And during this period, he is going to be first informed of what he has been charged with. Now, this can change what he's actually going to be charged with. Charges can go up, charges can go down. People can have charges dismissed. He'll also be advised of his constitutional rights. Now, obviously not all his constitutional rights. In particular, at this point, he's going to be involved of his informed of the constitutional rights for counsel, in particular to have an attorney represent him, and that's pretty important. The next thing that's pretty critical is he's going to be given a date for his preliminary hearing. That is, and sometimes these things are combined. Sometimes you have a pretrial detention, but a preliminary hearing is going to be a little bit more elaborate, a little bit more formal. At the pretrial detention, he is going to be made aware of his bail, if there is bail, and we're going to talk about bail coming up. If this is a misdemeanor charge, and in North Carolina, the typical misdemeanor charge carries a penalty of no greater than, assuming there's no past criminal record or anything, the maximum usually is about 180 days or 6 months. In theory, in North Carolina, it could run as long as 2 years, but I've never seen that. But in a misdemeanor, you even at pretrial detention hearings, you can be given the opportunity to plead guilty and take your sentence, which for certain misdemeanors might be time served or a fine, something along that regards. Okay, the next thing, like I said, we're going to talk about bail here. The pretrial detention, this initial appearance, we're going to set bail. Now, bail is becoming slowly but surely inside our system a much more controversial issue. I think one of the things that happens historically is each generation of people, each generation of lawyers, as it comes up in judges, begins to examine things that in the past were taken for granted, or alterations or suggestions for changes if this existed on the fringe. Bail is one of these things that people have been looking at. We have a constitutional framework within which this operates. The 8th Amendment of the Constitution of the United States prohibits what it calls excessive bail. However, it doesn't really define what excessive bail is. And for someone like Bill Gates, one of the richest men in the world, if you said your bail is $1 million, I'm sure he probably has that in pocket change. But if you talk to a homeless person and you said your bail is $100, I mean, they probably don't have $100. So one of the questions I think that society is going to have to be addressing is there a proportionality to your situation? Are we using bail in some ways now as a mechanism of punishment against poor people, and a mechanism whereby wealth can be used really to transcend much of the criminal justice system. Now, you are not guaranteed the right to bail. There are certainly certain circumstances, particularly if there's a danger of flight, where we can deny you bail. If people are unable to afford to pay their bail, so let's suppose someone gets a $100,000 bail. Very few people have $100,000 in cash that they can lay their hands on. So usually what happens is we seek out a bail bondsman. So my client, let's say, had a $100,000 bail. I could go to a bail bondsman and say, we want you to post a bond for the $100,000. My client then has to come up with 10% typically of this amount. So he would have to come up with $10,000, which for at least some people is a much more realistic figure. He gives that money to the bail bondsman. That money is gone. Even if he's found not guilty, the bail bondsman keeps that. The bail bondsman posts the bond, which is the guarantee that he will come to trial. That is, the defendant will go to trial, and the defendant gets out until trial. Now, one of the most common things we see, particularly for minor crimes, is ROR, which is called released on recognizance. Sometimes you hear people call it here released on your own recognizance. But basically, it's where you say, we're going to trust that you're going to show back up. And for a lot of very minor crimes, this is reasonable. I mean, why impose a bail? Someone who has ties to the community or has, a significant reason to definitely show up for trial. So ROR is a very common thing for minor crimes, particularly nonviolent crimes. Now, the preliminary hearing, which some of these things, as I said, can be combined with the beginning of this. The preliminary hearing, one of the things that we're going to question is, do the police really have the evidence they claim they have? Because the police, like any other organization, will make mistakes. The police sometimes will misinterpret the law or misinterpret the evidence. So we have, sometimes at least, a preliminary hearing. And this is kind of a mini trial in front of the judge in which a defendant has counsel and the prosecution comes forward with just enough evidence to convince the judge that, yes, viewing this evidence in a light that is really favorable to the prosecution, that there is sufficient evidence to go to trial. Not that there is proof beyond a reasonable doubt, that's the standard for conviction, but really that there is more than a mere hunch, more than a mere guess, that there is sufficient evidence that this individual committed a crime. So, at this preliminary hearing, we also begin to get an idea, if you're a defense counsel like I was, you're going to begin to get an idea of what the basis of the prosecution's case is. You don't get everything. You're going to get a glimpse at what evidence they have. Sometimes this stage has really happened before. Now, North Carolina doesn't use grand juries at the state level very much, but many states do. So we'll just touch on this, but be aware that in North Carolina, with the exception of certain drug kingpin charges and a few things like that, you don't tend to see a lot of grand juries at the state level. Federal, yes. A grand jury is an impaneled body of citizens. So let's take a federal grand jury. You might have 15, 18, whatever. You might have whatever number. And the prosecution will come in front of them and will present evidence that someone committed a crime. Now, that person's attorney is not present in front of the grand jury. So the legal maxim is, if a good prosecutor can indict in front of a grand jury a ham sandwich, because it's so easy. There's really no standard that's difficult to reach here, because he's the only one presenting the evidence. So he presents the evidence. If the grand jury says, yeah, there's probable cause there, we'll go ahead and issue an indictment, which is essentially go out and arrest the guy. Okay, this is one of the most important things to take out of this chapter, and that is that the prosecution here has a tremendous amount of power. Prosecutors can decide, will they go forward with a case? They can decide what charges. Are we going to put a lot of charges? Are we going to put a few charges? Are we going to increase charges? Are we going to decrease charges? Are we going to dismiss charges? So the process is, we would like to say, a completely fair, a completely rational process. And in many ways, there are certain aspects of that is true. But don't forget, prosecutors are political figures. Prosecutors are individuals. So they're going to come to make these decisions with agendas, some covert, some overt. And it may, make some people uncomfortable the way they make their decisions. And there's very little review of this. In fact, almost no review if a prosecutor decides he doesn't want to go forward. One of the things that might play into this, your book here is talking about scarce resources. I mean, can they prosecute every crime? The answer is no. So one of the things is they might decide, yeah, we're going to go forward, or, and here's a bit of Latin that your book throws in, nolo proseque, no, where the prosecution is going to decline to go forward. Either the crime is minor, or sometimes we don't think we can win as a prosecutor. Okay, so here are some reasons they look at. Can they get a conviction? Prosecutors, like everybody else, want to win in this system. If they can't win the case, very often they'll dismiss the charges. How serious is it? Prosecutors are loath to dismiss serious felonies, murders, rapes, kidnappings. Minor crimes, parking tickets, things like that, yeah, I mean, that's not a big deal for them. Cooperative victims and uncooperative victims. How is the victim going to play in front of a jury? Are we going to believe them? Are the victims reliable? And is the defendant willing to testify against other defendants? Can a deal be made? That can be very important, whether we will or will not go forward with a prosecution. Okay. At this arraignment, defendants will get their formal charges, and the judge will say, okay, give me a plea. Now, your book says there's 3 pleas here. There is actually more. North Carolina, for example, has something called the Alford plea. But generally, you're going to see the first 2 are 99.99% of the time. Rarely will you see a nolo contendere plea, but guilty, self-explanatory. You get charged with, say, speeding. You get charged with simple assault, which is a misdemeanor in North Carolina. You might say, well, I don't want to go to trial. I don't want to spend the money. I'd rather spend 30 days in jail or whatever I'm going to get, so I'll plead guilty. If you don't plead guilty, you plead not guilty almost always. Not guilty says, I want to go to trial. Let's go forward. The third option, which most people are unfamiliar with and you don't see a lot of, is called nolo contendere, which literally translates from the Latin as no contest. What this essentially means is you say, you've got enough evidence to convict me. I didn't do it. I will plead nolo contendere, which functions almost, in the trial instance, like a guilty plea, where it has some positives, however, for the defense, is that you can't sometimes use that guilty plea in the future against him. So if we were in a 3 strikes you're out jurisdiction or something like that, a nolo contendere plea, or in some certain, or in civil cases, a nolo contendere plea couldn't be used against him. You don't tend to see it too much. It's pretty rare. Okay, now let's talk about plea bargaining, because the most common thing that occurs here is not a trial, but a plea bargain. When I first started practicing law, almost 30 years ago, as I said, more than 30 years ago, about a quarter of all my cases would go to trial. So if I got a misdemeanor case or a felony case, I could count on the bulk of them being plea bargain, but I could be down in district court at a trial every week. By the time I basically stopped practicing full time, and today, fewer than 3% of cases go to trial. So 97% of the time, what we're really talking about here is a plea bargain. So a plea bargain takes place after the arraignment, but before the beginning of trial. And plea bargains really fall into two primary categories. Are you going to reduce the charge? So let's suppose I charged you with second-degree murder, and you'll say, all right, I'm going to plead, and you're going to charge me with a manslaughter, involuntary manslaughter, or voluntary manslaughter, more likely. You could also agree to a sentence reduction or a fixed sentence, where the prosecution could say, well, we're seeking a 10-year sentence, but if you plea bargain, we'll seek and agree to a 5-year sentence. So why do people plea bargain? Why does the prosecution plea bargain? It's quick. They also have limited resources. In many cases, a defendant does it because acquittal is a rare thing. Most people that go to trial get convicted. And typically conviction sentences are higher if you go to trial than if you take the plea bargain. And you have some control. You'll notice here in this graph that if you look at, say, the sexual assault here, I hope this arrow shows up, you'll notice that the average maximum sentence there is, more than 10 years if you go to trial. But if you don't go to trial, you can see how it falls to around 7 years or so. So it's a significant difference. In all cases, your sentence is going to be lighter if you take a guilty plea than if you go forward and you try to plead and try to have your trial. Okay. Speedy trial. This is required by the 6th Amendment of the Constitution, and all 50 states have their own speedy trials, but it doesn't really start, first of all, until you're actually accused. It's not when the crime occurs, because you might have a crime occur and the police might take 6 months or a year or 2 years, or with DNA, 10 years to solve something. So we're not going to run that. Also, you're going to have a statute of limitations. Now, not all states have a statute of limitations. North Carolina has no statute of limitations. So in theory, if you had committed a bank robbery in the 1920s or 1930s, and we caught you today when you're in the nursing home when you're in your 90s, we can go forward. Most jurisdictions will have limits on that. North Carolina does not generally. Okay, the jury. Now, again, this is a heavily constitutional, and there's a lot of cases here, and if you take constitutional law, I think you're going to see that. But in all felony cases, you are entitled to a jury trial. So if you are going to serve more than typically, in most jurisdictions, a year in prison, you're guaranteed a jury if you want one. And it has to be an impartial jury, whatever that means. And that's something that we've struggled for in America, defining what an impartial jury is. Typically, juries are 12 members. North Carolina almost always. Most states require unanimous verdicts, so all 12 have to vote to acquit, or convict, excuse me. If you don't have a unanimous verdict for acquittal, then typically you have what's called a hung jury. We'll talk about that. Defendants can waive your right to a jury. That's pretty common. North Carolina has made that easier versus some constitutional amendments that recently came in. You also have a privilege against self-incrimination. Self-incrimination is usually called taking the fifth, where you say, I don't want to testify. Now, why would someone not testify at their trial? Doesn't that mean they're guilty? And the answer is no, because some people are very bad witnesses. Some people would alienate a jury. Some people, if you called them, the prosecution might be able to bring up something really unfavorable about them that doesn't relate to this crime. So as an example, let's suppose you had someone that was a bad individual, say he was in the Ku Klux Klan or a Nazi. And if he took the stand, the jury was going to find out he was in the Klan. But his current arrest, let's suppose it was for jaywalking, had nothing to do with him being in the Klan. But if the jury heard about that, the likelihood of conviction goes up dramatically. So Taking the fifth can be for lots of reasons. Maybe you're just bad at testifying. Maybe you would alienate a jury. It should not prejudice the jury, and the judge is going to have to clearly explain to the jury that because he didn't testify doesn't mean you can find him guilty. All right, there is, at least in theory, a presumption of innocence. I would say in practice that's not too true, because we say there's a presumption of innocence, but in fact most people are convicted, and unless we've got a very perfect system, which I don't think we do, what I would say is more likely is you have a presumption in front of a jury in particular, and even a judge, that you're guilty of something at least. We have a standard of proof called proof beyond a reasonable doubt. Now that's a little bit higher than the civil standard, which is preponderance of the evidence. It basically says that not that there's no possibility you didn't do the crime, but that a reasonable person looking at this, examining the facts that have been presented to the jury, would say that, beyond a reasonable doubt, beyond not any doubt, but a reasonable doubt, yeah, the guy committed the crime. All right, now let's talk about jury selection. First of all, you have what is called, that last term on that slide there that you're seeing, venire. Venire is the jury pool. And this was one of the areas in the past where there was a real problem, particularly here in the American South, but in other places in the United States. Out west, for example, they excluded Indians or Native Americans. In the South, they excluded African Americans. So the venire at one time was just white male property owners. And that meant the jury could be very different than what the defendant was. Gradually, the Supreme Court has broadened that, so that using different things like voting lists and more than tax rolls, now the venire is a better cross-section of the people that live in a jurisdiction. We then go through, if you're on the venire, you have to be a U.S. citizen. You can't be a felon or convicted of one. You got to be healthy. You got to understand, and you have to be able to read and write. Now, that understand provision means you can comprehend and you can express yourself. You do not have to be a genius, but you have to have a certain level. We question the venire, the potential jurors, via a process called voir dire, V-O-I-R-D-I-R-E. Now, it gets pronounced different ways, and the pronunciation is not critical. You hear it pronounced voir dire or voir dire, doesn't matter. But these are the questions we ask, and what we're looking for is, first and foremost, are any of the jurors prejudiced, or do they have a connection to the case? So if someone's on trial for robbing a bank, and one of the people from the jury pool, the venire, is someone who works in that bank, well, we're not going to let them sit on the jury. Or if they say, well, I hate all, let's suppose the person on trial is an albino, and the person in the venire says, well, I hate all albinos. All albinos are bad. I just hate them. Well, you would excuse him from sitting on the jury. Now, the two ways you exclude them is you can challenge them for cause. This is the easiest way. You can simply say, this person has exemplified some prejudice or has said something that really would prohibit him from rendering a fair or good decision, so we want him off. The other thing is, and these are more limited, you have an unlimited number of challenges for cause if you're a defense attorney, is a preemptory challenge. And there you say, I don't know what it is about this person, but I feel like he would be either against my client if I'm a defense attorney or against the state's case if you're the prosecuting attorney, and I don't want him on the jury. And for whatever reason, I'm going to keep him off. And that's called a preemptory challenge, and that usually can keep off, it varies from place to place, but at least 5 or 6 people. Now, one of the things the Constitution in its current interpretation, and this was the Supreme Court interpreting it, says that prosecution can't say, I don't want blacks on the jury, I don't want whites on the jury, I don't want someone on the jury because of their race or because of their gender. And if I can prove that as a defense counsel that they did that, then that is a basis for a mistrial. We'll have to have another trial. Okay, let's talk about the actual trial itself. We're going to do the opening statement. The opening statement is one of my favorite parts of a trial, because what you get to do in North Carolina, and this is unique, is you actually get to stand up. In North Carolina, unless you're addressing a judge or approaching a witness to provide evidence or submitting something, you stay seated next to the defendant. The prosecution stays seated. You don't get to pace around. You don't get to control the courtroom physically with your presence. Opening statement, you can stand. And in the opening statement, you're going to give the jury or the judge, if it's a bench trial without a jury, you're going to give the judge an overview of the case. One of the things I would do in an opening statement is I would emphasize the strengths of my case and the weaknesses of the prosecution's case and draw attention to those. Try to get the judge or jury thinking in a particular way. Now we're going to have the evidence, and after opening statements, the prosecution presents its case. He or she is going to provide witnesses who are going to bring in evidence. And there's lots of rules. There are rules of evidence, an evidential procedure. They're fairly complex. Evidence, really, there are three great gatekeepers here. Is the evidence competent? Is the evidence material? Is the evidence relevant? So, can we trust it? That's competent. Is it relevant? Does it matter? And is it material? Is it important enough? So there can be two categories of evidence. There's testimonial evidence. This is what I saw. And then there's real evidence. Here's something I have to show you. And all real evidence gets in via testimony. It doesn't float in by itself unless there's an admission. Okay, direct evidence shows things immediately. Quick example. A direct evidence, you walk into a room, you see Fred standing over Barney. Fred takes out a gun, shoots Barney 5 times. You have direct evidence that Fred shot Barney. That's great. Circumstantial evidence. You're standing outside a room, you hear 5 shots, you walk in, Fred is standing over Barney, Barney has 5 bullet holes in him. You don't have direct evidence that Fred shot Barney, but you have very compelling circumstantial evidence. Is it possible Barney shot himself 5 times and Fred just picked up the gun? Yeah, pretty unlikely, but possible. But you have a very strong indirect case. So what I'm trying to show there is direct evidence is great. Circumstantial evidence can be really good. Relevant evidence tends to prove or disprove something that's important to us. Prejudicial evidence is evidence that if you showed it to them would overcome, usually by an emotional bias, would overcome the jury or the judge, rarely the judge. So prejudicial evidence can be excluded. It tends to be something that simply excites people's emotions beyond what's necessary. Okay, the prosecution's case, he is trying to establish the body of the case, the corpus delicti. He does this, first of all, by direct examination. Now, during direct examination, this is what most attorneys would say is, tell me a story. You don't guide, besides asking just general questions, direct examinations. You ask the witness very broad questions, and they provide the answers. You do not lead them. And you do have to be careful here about hearsay. So hearsay is admitting evidence that they heard something and they're repeating what they heard. That's more than that. It's in fact an out-of-court statement being offered for the proof of the matter asserted. All witnesses, of course, must be competent. They must be able to have perceived the event, they must have been able to relate the event, and they must be able to do this truthfully. The next, and I would argue most important stage, is confrontation, cross-examination. Anyone can tell a good story. Those of you that have me in class know that I often make fun of ghosts, people that believe in ghosts, or UFOs. there's lots of stories about UFOs and little green men. That's great. You can tell a really good ghost story too. But when you start to ask questions about the ghost, or when you start to ask questions about the UFO, when you start to ask questions about some outrageous story someone's telling, the questions usually get you quickly to the point, well, this is just a story. Or, oh yeah, yeah, we saw this ghost. Wow, that's a really interesting story. What were you doing when you saw it? Oh, I was drinking. Oh, you were drinking. I was doing mushrooms. Well, okay, well, that might be an explanation then. I was taken up in a UFO and we went to Venus. That's great. Where were you right before that? Oh, I was in a mental hospital. Okay. That the confrontation clause is so important because you have a fundamental right to cross-examine people, and the cross-examination typically gets us closer to the truth. The confrontation clause, we're going to find that in the Sixth Amendment. Now, I had mentioned hearsay here, and your book kind of overstates this. So hearsay is one of those rules that you frequently see in TV dramas where an attorney steps up and says, "Objection, Your Honor, that's hearsay." And hearsay is an out-of-court statement being offered for the proof of the matter asserted. And it can be an oral statement or it can be a non-oral statement, a written statement. It doesn't matter if you write something down. And having said that it's inadmissible, that's certainly a true statement, but there are at least 23 exceptions to the hearsay rule. So very often hearsay does get in. But the classic example of this is, you have all heard the Gettysburg Address. It starts off 7 years ago. You've all heard that at some point in your life. It's a relatively short speech. It's a couple hundred words. But could you accurately repeat the entire speech? Well, I might remember some of it, Mr. Chapman. Well, that's not good enough if you're testifying in a courtroom what the content of the speech was. So we exclude hearsay because people don't have tape recorders. People don't remember things exactly. Okay, after the prosecution goes, at this point, they rest. Usually I'll make motions at this point saying, okay, they didn't prove this. I'd like to reduce charges or dismiss charges. Usually you're going to have to go forward. Alibi defense, very often used. You claim my guy robbed the Piggly Wiggly on June 1st at 6 p.m. I've got an alibi. My guy was in California on June 1st at 6 p.m. in the Los Angeles County Jail, and here's his record. That's a really good alibi. There can be other defenses, self-defense, insanity, duress, entrapment. All those can be used. Rebuttal means the prosecution, after I brought up some evidence, wants to bring up some counter evidence. Then after they bring up their new guy, I can bring up my new guy. That's rebuttal, insert rebuttal. After that goes on, after they've done their case, I've done my case, we each do closing arguments. I go first as the defense counsel here. Usually what I'm going to emphasize is I'm going to look for some reasonable doubt that the prosecution really failed to make their case. After closing arguments, it's going to go to the jury. The judge tells the jury, here are your instructions. This is the standard you should use. These are the laws involved. The jury goes back. It makes a determination of guilty or not guilty. If it can't, if it's split, we call it a hung jury. And if there's a hung jury, you can have a retrial. You're not acquitted. If the jury comes back and says 12-0, you didn't do it, congratulations, you're acquitted, you're done. If it comes back and says 12-0 that you did do it, you're convicted. But if it comes back and says, well, we had 6 people that said guilty and 6 that said no, or 11 people said you weren't guilty, but 1 person said you were, we still can have another trial there. That's still a hung jury. If, however, you are convicted, or if you are acquitted, the Fifth Amendment attaches. At this point, it's up to you. You cannot, if you're acquitted, that's it. There's no retrial. So if you took someone who was acquitted of a murder, Famously, O.J. Simpson was acquitted of killing Ron Goldman and his wife, Nicole Brown Simpson. If you found a videotape tomorrow of him killing them, you could not retry O.J. Simpson because he has been found not guilty by a jury. If you are convicted, you might say, well, I was on trial for first-degree murder. They convicted me of voluntary manslaughter. I'm happy. That's great. As opposed to facing the death penalty or 20 years in jail, I'm going to get 2 or 3 years and then probation. The prosecution might say, well, we're really upset. We'd like to have another trial. The prosecution can't. Only if the defense appeals does he waive double jeopardy upon a conviction. If, however, there's a hung jury, knock yourself out. We can have a whole new trial. If people aren't happy with the verdict, there is an appeal. And we're going to, usually these are errors of law we're looking at. Okay. The appeal, one of the final procedures after appeal is we want to bring them into federal court, sometimes state court. That's a habeas corpus writ. Why do people get wrongfully convicted? Because it does happen. Well, eyewitnesses can make misidentification. It's pretty clear that we don't have cameras and that we do not see things sometimes, or we see the wrong thing. There are false confessions. Sometimes people, surprisingly enough, will confess to crimes they didn't commit, particularly if they are being coerced into it. It can be a physical coercion, it can be a psychological coercion. There can be bad forensic evidence. There can be people that don't do blood tests right or don't do DNA tests right. An informant can have lied for his own benefit. There can be law enforcement misconduct. Police officers can frame people sometimes. So all those are a basis for convictions. All right, that concludes our lecture. That brings us in at about 37 minutes or so. We'll end it there.